This is what the Supreme Court said about the result of the Brexit referendum in paragraph 7 of its judgment. The government had pledged to honour the result, and it has since been treated as politically and democratically binding. Successive governments and Parliament have acted on that basis. Only Remoaners would make that claim.
I think I better sum up and finish. In Whiteman, before the full court of 27 judges in Luxembourg, the President Kuhn-Lennox said, "This is our Marbury against Madison moment." What he meant was by that, I think, that it was the realisation that within the European Union legal system, this was a fully and properly constitutional moment. I say to this court, don't let this case be your Dred Scott moment. Instead, stand up for the truth, stand up for reason, stand up for unity in diversity, stand up for Parliament, stand up for democracy by dismissing this government's appeal, and uphold a constitution governed by laws and not the passing whims of men. We've got here the Mother of Parliament being shut down by the Father of Lies. Rather than allowing lies to triumph, listen to the angels of your better nature and rule that this prorogation is unlawful and abuse of power which has been entrusted to the government. This government is showing itself unworthy of our trust as it uses the powers of its office in a manner which is corrosive of the Constitution and destructive of the system of parliamentary representative democracy upon which our union polity is founded. Enough is enough. Dismiss this appeal and let them know that. That's what truth speaking to power sounds like. Lords and ladies.
Clearly he thought he was starring in a Hollywood movie. Unfortunately, the Supreme Court has agreed with him. That's what happens when you change the law lords to something called the Supreme Court. For centuries, it was unthinkable that British judges would interfere in political matters because of the ethos of duty and service they were imbued with. That ethos is now shot to shreds. The Supreme Court has once again ruled as part of a rolling Remoan coup against Brexit. Let's listen to the crux of the court's judgment.
Bound to conclude, therefore, that the decision to advise Her Majesty to prorogue Parliament was unlawful because it had the effect of frustrating or preventing the ability of Parliament to carry out its constitutional functions without reasonable justification.
Let's go to paragraph 44 of the judgment. Statutory requirements as to sittings of Parliament have indeed been enacted from time to time. It goes on to list them and says, but they do not address the situation with which the present appeals are concerned. So the judgment recognises two things here. Parliament has the right to speak and vote to pass legislation on prorogation and has done so. None of the legislation it has passed covers the Prime Minister's prorogation of Parliament. Let's now see what the court says in paragraph 68 of its judgment. The prorogation itself takes place in the House of Lords and in the presence of members of both houses, but it cannot sensibly be described as a proceeding in Parliament. It is not a decision of either House of Parliament, quite the contrary. It is something which is imposed upon them from outside. It is not something upon which the members of Parliament can speak or vote. This is spectacular sophistry from the Supreme Court. Obviously, at the point at which Parliament is formally prorogued, members of Parliament cannot speak or vote to stop it. But as the court is perfectly well aware, Parliament had 5 weeks formal notice of prorogation and 5 sitting days after recess before it came into effect, which gave it ample time to pass a bill to revoke prorogation had it genuinely thought it necessary. We know for a fact Parliament had ample time, as it passed its Stop Brexit legislation, 2 other acts of legislation, and twice voted down government bills to hold an election. Aiden O'Neill, QC, once more.
Is this internal issue about is being suggested? I think that Parliament could have, in the short period it had left to it before prorogation, once it knew about prorogation, have legislated to have against its prorogation in some way, instead of spending what little time it had on passing the Ben Act requiring an extension. So, second-guessing Parliament. So I think the suggestions then made, because it didn't do that, then Parliament's perfectly happy to be prorogued, and it would be an intrusion on the separation of powers if this court were to suggest otherwise. Well, I'm sorry, but the whole point about an act which would affect the prorogation power, the prerogative, is one which Erskine May tells us requires the Queen's consent to the bill. So this government could have said, if you try and affect our prorogation power, we will not give the necessary assent to the bill before it even gets to through the whole processes of Parliament and is set to royal assent. So they held all the cards in that regard.
So, by Mr Neill's own admission, prorogation is something Parliament can speak and vote on. Ergo, it meets the Supreme Court's own criteria as a parliamentary matter outside the court's jurisdiction under Article 9 of the Bill of Rights 1688. His concern is whether, if passed, the government would have passed the bill to Her Majesty for her royal assent. If that happened, that the bill wasn't passed to Her Majesty, Remoan may or may not have had a basis to take the matter to court. But it didn't happen. What we are left with is a Supreme Court that, by its own criteria, is in breach of Article 9 of the Bill of Rights 1688. That the freedom of speech and debates or proceedings in Parliament ought not to be impeached or questioned in any court or place out of Parliament.
It was being suggested by the, again, I mean, I draw the analogy, the idea that, well, Parliament had 4 days, they passed one bill, but they could have passed another bill. It's like an arsonist has come into your house and, the fire is raging in the kitchen, and you try and put it out in the kitchen, and then they say, yeah, well, you didn't do anything in the living room, so you must have consented to it being burnt down then. I mean, there's only so much time that people have to deal with firefighting, to deal with the crisis.
Mr O'Neill's reference to fire may be regarded as Remoan's Reichstag moment to facilitate a judicial coup against the Prime Minister to politically damage him to further the election prospects of Remoan. This is what the Supreme Court said about the result of the Brexit referendum in paragraph 7 of its judgment. The government had pledged to honour the result, and it has since been treated as politically and democratically binding. Successive governments and Parliament have acted on that basis. Only Remoaners would make that claim. At all points of the appeal, this is what the Supreme Court President, Justice Lady Hale, has been at great pains to stress.
It is important once again to emphasise that these cases are not about when and on what terms the United Kingdom is to leave the European Union.
Milady didst protest too much, methinks. The spectacular sophistry of the judgment and its partisan Remainer point shows it had everything to do with Brexit.
Order of tomorrow. The world order of tomorrow is not a world order based on nation states or countries. It's a world order that is based on empires.
The empire has struck back yet again, but this is not a movie. This has the beginnings of a civil war in which real blood shall be shed and real lives will be lost. The only way to stop this constitutional crisis spinning out of control to reach that point is if our Remoan Parliament has enough respect for democracy to pass a vote of no confidence in Her Majesty's government, to vote in a new one or face elections, or accept Her Majesty's offer twice made of an election. Unfortunately, Remoaners would rather continue their rolling coup and risk a civil war.